How's everybody doing? Well, this is windshield time. I'm on my way to Huntsville to fight for a father's right to see his children. You know, if you read the comments, and just a little brief overview of windshield time. Windshield time is where I will be addressing the various issues of national, international prominence, things related to law, and, you know, possibly addressing some comments or other things. Windshield time is extemporaneous, it's from the hip. There may occasionally be cuss words, there may be some vulgarity. It's an unvarnished look, man. When you strip away the pretenses, that's me. So, one of the complaints that you see when you read through the comments is, well, I'm a lawyer, so of course I would see things, you know, anti-people, or I would be biased. Well, yeah, there's some of that. But the reality is, lawyers are hired guns. We fight for people that may not be able to fight for themselves effectively. So it bothers a lot of people when they see lawyers as a class that aren't fighting for what they believe in, what the person viewing the class of lawyers believes in. Lawyers are hired guns. We represent our client's interest. Very few lawyers are interested in the broader subject of justice as a whole. It's what does the law allow, what does the law prohibit, and how does that function in society. The lawyers that are interested in justice as a whole are largely prosecutors and judges. Some civil rights lawyers, but they're not really truly interested in justice as a whole. They're interested in justice for their clients. And that's what we all are. We're interested in justice for our clients and what our client views as justice. That's the hired gun part of it. I'm not here to be fair to the other side. I'm here to help my client. Now, the issue when you come into fundamental rights like First Amendment, you've also got to look at things from the other side if you're going to give a balanced analysis. For example, the situation with furry potato. For those of you who don't know or haven't followed this at all, furry potato is a transgendered activist in California who was taking pictures of a Jewish synagogue school and shot video the entire time. During the course of her walking around the school, albeit in public areas, she went nowhere that I'm aware of that she wasn't legally allowed to be. But the security guard was very anxious. She did do some things that I don't approve of. I mean, look, peering in windows, taking pictures in windows, I disagree with that. I think that's crossing the line. But the security guard became very anxious and upset. Now, during the final minutes of the confrontation, when the security guard drew his firearm and threatened to shoot her, and then ultimately did fire a round, there's some question as to whether that was a warning shot, like the security guard said, or negligent discharge. I personally believe it was a negligent discharge, and the security guard was trying to cover his ass by saying it was a warning shot. So, that said, that's where that seemingly ended. Law enforcement arrived. First they took Furry Potato into custody, then they arrested the security guard, and ultimately the district attorney in California decided that the security guard has a valid claim of self-defense while he was on the other side of a locked gate pointing a firearm at an unarmed person when he fired. I fail to see how that actually would work, but the prosecutor is the one that makes that call. There's no way around that. Sorry. However, Free Potato has hired private counsel and is engaging in a civil lawsuit, presumably against the guard, the security company, and the Jewish synagogue and school that hired them. I expect that will be a successful case, and there will be a settlement. But a number of people take issue with a balanced look at this. The balanced look is, what was happening, how did it happen, and how could it be perceived on the other side? Most of the First Amendment crowd will freely agree that Free Potato had a right to be on a public sidewalk. Free Potato had no obligation to engage verbally with the security guard. People who want to be reasonable about it will acknowledge that when someone's threatening you with a firearm, it might be a good idea to be anywhere else but there. That said, does the security guard have a valid claim of self-defense? Well, I'm not a California lawyer, but I can't see one. You can look at the intricacies of the law in California, how it's written, how courts have ruled, and maybe. But quite frankly, I think that Free Potato has just pissed off the powers that be. And I would hope she would agree with this next statement. It simply has been a pain in the ass to the cops and the system long enough that they're declining to appear to be on her side. So it'll have to be handled civilly. That it will be settled civilly, no doubt. She's probably looking at a high six figures judgment or settlement. I can't imagine they'd want to put a shooting case in front of California jury. I wouldn't want to. So that's that balanced look, because nobody likes it when you look at the other side's argument, the other side's position. And you have to stop when you're analyzing something and determine, do they have merit? The only way you can do that is by granting them that merit when you review it and seeing if the argument will hold up. And there's nothing wrong with that. Lawyers have to do that every day on every case. The one I'm driving to right now, have to review the other side's argument. Does this argument have merit? Well, obviously I'm not going to go into that case, but any particular argument may. If it does, you have to handle it. How do you handle it? Well, in Free Potato's case, they filed a civil suit. They're going to handle the objections and the arguments in the course of that, and they'll reach an eventual resolution of the case. There's no way that holds up. Of course, now that's going to bite me in the ass. Earl David Warden, News Now Houston. A lot of people in the auditor community seem upset with him. They feel like they've been lied to. I don't know why. Well, he didn't tell us that he was a sex offender. Well, you know what? I can't imagine that being the first thing he ever wants to say to somebody when he meets him. Hi, how you doing? I'm a sex offender. Nice to meet you. I'm a sex offender. That's just not realistic. It's a part of his past. It's part of his present reality. It's not a pleasant part. It's not surprising that he doesn't want to talk about it or didn't want to raise it whenever he met someone. Other than the allegations that they made going back to, what is it, 2002 now? You know, no one has come forward and said that he's done anything in the recent history as a sex offender. Now, has he had other problems? Yeah, sure. But we don't judge people on a current charge based on prior allegations or even prior findings of guilt. Okay? Every individual charge is judged on its own merits. And believe me, I've gotten hammered by some people on this. The man deserves a defense. He deserves the best defense he can get. The truth, I truly hope, will come out. But before we take somebody's liberty away in our society, they have a right to a defense. They have a right to the best defense attorney they can get. Okay? We don't strip away somebody's liberty on the basis of an accusation. The evidence has to be tested. It has to be proven. So, no, I'm not in favor of child molestation or child molesters. However, I'm certainly in favor of a man having a right to a defense when he's been accused of a crime. Now, let's set that aside and talk about what the issues and the problems are with, God, just this avalanche on David Warren, Earl David Warren. Mr. Warren he seems like a nice guy. You look at him on video, I mean, he's a decent looking guy. He talks fairly well. You know, he comes off, presents himself fairly well. But people are hurt. People that really care 100% about the auditing movement are upset because this brings a negative light upon auditors in general. Just frankly, in our society, people don't want to associate with child molesters. They don't want to be associated with child molesters. But in their own disgruntled responses to and about Mr. Warden, they overlook the fact that the First Amendment exists to protect the speech rights of the most unpopular speech and the most unpopular speakers. Can there be a more unpopular speaker than a registered sex offender? You know, I don't know, but I think you'd be hard-pressed to point one out. The First Amendment exists to protect exactly him. Now, as far as his issues with law enforcement, yeah, he's had a few. I wonder if some of the problems he's had relating to law enforcement on the street is because they know his record. You know, police are people too. You can't expect them to have the same approach with a registered sex offender that they would have with a person who isn't. We would hope that they would. We would hope that they are able to set that aside. But man, cops are human too. And contrary to popular opinion or belief right now in America, cops are not out to step on your throat with the jackboot of society. Most cops are decent, honorable people who are doing a job because they care. Will they make mistakes? Hell yeah. They're going to make mistakes. I mean, who doesn't? If you want to be honest, think about your own job. Think about the mistakes you made last week. And for auditors, I mean, if you think about that, then think about someone putting your mistakes on YouTube for the world to watch. Excuse me, sorry. So, yeah, I can understand cops being a little camera shy. I can understand being a little irritated when people are doing that. Nobody likes to be embarrassed. Frankly, that's the number one thing going when you cross-examine a cop. They don't like to be embarrassed. That's where cops get in trouble. If they just admit on the stand they made a mistake, man, defense attorneys and clients are screwed. Because, yeah, I made a mistake, man. You know, I didn't do that procedure properly. I made a mistake. But it doesn't change the fact that, you know, the guy was drunk. Well, okay. We're going to try and drive a semi-truck through every one of those mistakes. But that's a lot harder to defend against. Because the jury is going to give the cop that benefit of the doubt. People make mistakes. Anyway, so that's the auditing cleanup. Man, medical marijuana, Missouri. They just dropped 5 new draft rules on Friday. Excuse me, 4 new draft rules on Friday. So there are 5 draft rules that are out. We did a video on one, the qualified patient and caregiver draft rule. The other 4 they dropped, we're going to do videos on. That'll be over the next 2 weeks. I'll do a brief overview and then we'll do a video on each one. Medical marijuana is important. It is an important issue. It is a freedom issue. It is a liberty issue. There's no reason for the government to criminalize marijuana, especially under medical conditions. So it's something that we are tracking. I do a significant amount of business on criminal defense in regards to marijuana and marijuana related issues. It is unfortunate, and I truly hope that that business goes away once we have medical marijuana coming online. There are a number of concerns, though. The earliest a facility could be licensed is going to be the end of December, January of 2020. December 19 or January of 2020. However, under the new proposed draft rules, the licensing is going to be conditional. Okay, it's a provisional license that you have to construct the build out. It's got to be inspected, and everything has to be, you know, I's dotted, T's crossed before the full license is granted. And what that means is that there's a lot of companies that are going to be taking a chance. They're going to be investing millions of dollars. And they may still have their license denied. One of the requirements for staff at a marijuana facility is that every staff member is going to have an identification card that they have to get. The employee identification card is going to cost around $150, I believe it is. That's in the draft rules, and we'll talk about that in the future. But those won't be issued until like February, March of 2020. That's going to present a significant issue in getting your medical marijuana in production and out. With that in mind, I just don't see medical marijuana hitting the streets, in dispensaries for sale before early summer of 2020. it's just not going to be possible. And that's going to be a significant issue in people taking advantage of that right. So we are going to do more in the medical marijuana. We're going to do more in general law, things like, you know, a couple popular videos we had. Can you flip off a cop? You know, is it legal? And what to do. Cop smells weed in your car. What do you do? Those videos were fairly popular. We're going to do some more generalized stuff like that. Not necessarily focused on a specific state, but to the extent that it is, it's focused on Missouri, because that's where I'm licensed. So with that in mind, I'm going to say thank you, and I appreciate your tuning in. Please like, subscribe, and if you are in Missouri, you are interested in medical marijuana, we have lease addendums for tenants and landlords in the state of Missouri for medical marijuana leases that will allow you to protect your right to use or even home cultivate your medicine. Or as a landlord, it can be used to bar somebody from using or cultivating in your property. Those addendums are $25. They're available on pattalkslaw.com. And thank you. We'll look forward to talking to you soon. Bye.